one night. Said let's start with a kiss, it'll be alright. But now she might have a bun in the oven times two, and neither of them knows what to do. It's a blow by blow. Who's the daddy show? Is it twins from a blowjob? Oh, I don't know. Paternity tests and lawyers in sight. This crazy situation just ain't right. He swears he's not the one to blame. Says it's biologically insane. But she's pointing fingers, shouting loud, while the lawyers gather in the legal crowd. It's a blow by blow. Who's the daddy show? Is it twins from a blowjob? Oh, I don't know. Paternity tests and lawyers in sight. This crazy situation just ain't right.
Sing along, everybody.
Legal advice says he takes a drink, says let's settle this without the legal stink. He challenges her lawyer, please be better. We don't need another bad letter. So let's raise a glass to this legal brawl. May sanity prevail and pride take a fall. Twins from a blowjob, what have you to hide? But let's find some peace. Let your conscience be your guide.
Okay, good morning, good night, good evening, good afternoon, in whatever order your day progresses, whatever you're doing it, who you're doing it with, etc., etc. I'm just glad you're doing it here with me today. Me, little old legal vices. That's me. Hi. We're taking a break from the Karen Reed trial today because it's a full day in court and I don't have a full day to devote to it. But tomorrow I'll upload the summary of what happened today, and then we'll watch it live tomorrow because it's a half day on Thursday. What we're doing today is we're looking at some more filings in the Clayton, Echard, Laura Owens mess. We'll call it a mess because it's kind of messy. And let's see, we got 245 people here already. Wow, that's a fresh number out of the gate, but only 110 of you have happened to hit that like button. Do the YouTube-y things, people. Come on, hit that like button. I mean, I'm going to lower my microphone here just a bit so we don't see it in the camera. There we go. Creak. Just like my joints, it just creaks its way down. All right. Make sure you hit that like and subscribe button. Subscribe if you haven't already done so. If you have, double check to make sure you have subscribed. We're trying to get to 76,000 and we're pushing upwards of 75,600. So we're continuing. 75,700 is just on the horizon. So let's make sure we get there. And we've set up a little like and subscribe poll here today. It's time for some introspection, people. Look inside yourself. Look inside your feelings and tell me how you want this to end. How do you think this case should end? So the idea is to take the poll after you hit the like and subscribe button. That's the whole point of the like and subscribe poll. But anyway, how do you want this to end? Your choices today are mass destruction, scorched earth. Everybody just walks away. Drop your hands and walk away. Everybody says, all right, just go our merry ways. And then can't we all just get along? And finally, hugs for everyone. Everybody makes up. Everybody feels good about themselves. Everybody feels good about how it turns out. And everybody lives on their lives, writing this off as some chapter in their respective lives they never want to relive again. Those are your choices for today. And we'll check on in about an hour to see how we're doing. But there's a few things we want to do today. I want to talk for a bit about this case. And then I want to read the first emergency motion to strike filed by Dave Gingras, Laura Owens' lawyer. And then I want to do this in chronological order. So then we'll read the most recent blog post and go through that together. The most recent blog post by David Gingras. And then we'll read the response, the reply in support of his. So basically he files the motion and then he files a reply in support of his own motion, sort of a way to supplement it. And we'll read a new affidavit from Laura. And if we have some time, we will look at the expert reports, because I haven't had a chance to talk, to actually even review in depth the expert opinion that he posted as part of his response to the fraud, the motion to set everything aside for fraud, the motion for relief. I can't remember what the hell the document was titled off the top of my head. But we've got the dogs in here. They're doing their thing, just kind of waiting to make their appearance on camera if that happens. Let me just really quickly tell you what's going to happen the next couple of days. As I said, tomorrow we'll be doing the Laura Owens. Nope, we're doing Laura Owens today. We're doing the Karen Reed trial tomorrow. We're covering that live. And then Friday will be our May F It Friday stream, where we say F It. We have a great panel of guests on, and we just sit and talk about stuff. In exchange, you bring your donations and you throw all your money at me, because it's just a grifty booze-a-thon. We do it once a month to get all the grifting out of the way, so we don't have to do it the rest of the month. But it's all fun and games. It's all tongue in cheek, and we just have fun. We know what it is, and we've got so far the panel is coming together. We'll be appearing with me on Friday at various times. We're going to start at 8 a.m. Eastern Time, U.S. Will be Moxie Dame Jess, Aussie Overlord Hayden. Danny on Direct will be popping in. Paralegal Liz, Nick Starro, Kaiser Pineapple is going to make an appearance. Ian Runkle from Runkle of the Bailey, and Law of Self-Defense Andrew Branca. We haven't had an Andrew Branca sighting around these parts for a while. And Meme Copium is doing his Friday stream the same time I'll be doing my Friday stream. So if he has any gas left in his tank when he finishes, he and Max Murrow will pop on over here and say hi. And everybody else I've been talking to about it is just waking up, and so they should be replying soon. But that's the panel so far, and people will come and go as they please. But it's my second year on YouTube anniversary, so it's my second YouTube birthday. We're going to be celebrating that. We're going to be celebrating hitting 75,000 subscribers. We're going to be also celebrating my vacation. I don't know why you'd celebrate my vacation, but yeah, I'm just grifting for vacation funds. And at some point during the weekend, I'm gonna have a very, I hope to be able to do it this weekend. It depends on the outcome of F It Friday. I want to have a very special, serious for my subscribers, for my viewers show. It'll be short, maybe an hour, maybe less, but I have some things that I want to talk to you about, seriously, from the bottom of my heart. And hopefully we'll be able to do that this weekend. That's what's coming up until next Monday, when we'll do Maritime Monday and repeat the cycle over again. All right. Hope you've taken the like and subscribe poll and got all that stuff out of the way. And this is a very reading intensive show. So as always, I won't be able to pay as much attention to the chat as normal, but every now and then I'll take a glance over there and see what's happening. So, you know, this isn't a grift. It's just me stating facts. The easiest way to get my attention, or to make sure your comment is read or your question is addressed and responded to, is a super chat, because it comes up in bright, flashy colors. And we do unleash Doggo Cam at the $100 super chat mark, and we'll see what happens there. But I'm just pouring myself a Boulevardier cocktail here, so we can chill on ice while we read to the beginning. We got the two dogs hyperventilating over here. And ever since yesterday, they were snoring hardcore yesterday. They were into serious bulldog snore mode last night. Last night my time. And all day today, I probably got nearly a dozen of you people DMing me pictures of my dogs hooked up to CPAP machines. So I might show a few of those later on in the show, or maybe at the end if you guys remind me. But all day long, because somebody posted something on Twitter with a bulldog on sort of hooked up to a CPAP thing, and I made a comment saying, "Oh, this is a necessary item," and then the DMs started coming in rapid fire, and I got like about a dozen of these things. But all right, let's talk about the state of this case. Oh, before we do that, ooh la la, Pat, all the way from France. Hey, just because you said super chat. Oh, I wished it was that easy. Let's try it again. Super chat. Let's see what happens. See if that summons the super chats. Thank you. Thank you so much for the €2.50. Thank you so much. All right. As I was saying, this case, we're coming down to the wire, assuming there's no more delays. There's no more extensions or continuances. Things should be working themselves out in about 1 month and 2 days from now. The hearing is scheduled for June 10th. And you guys may be surprised. I know I've talked about it before, but I don't know what you guys think. But you may be surprised. I am genuinely happy that David Gingras is involved in this case. I'm genuinely happy she's got a lawyer that is sticking by her side. Why is that the case? Because when we first got involved in this, Clayton had his own lawyer who was doing things in a very lawyerly manner, and she didn't. And so it was all over the map. She was saying stuff. She was slinging things around. Their hearings are being held. It was kind of a cluster F, and there wasn't really any direction to the case. Then lawyers would come on, and then for whatever reason, they would decide they don't want to be involved in the case anymore, or they can't be involved in the case anymore, as the case may be. And then she's left rudderless again. Then someone else comes in. Then they have to get up to speed. Then we get more continuances. I'm happy that David Gingras is here because she's got a lawyer who is a zealous advocate for his client. And do not forget it. She has every right to have a lawyer that is a zealous advocate for her. But it's giving the case direction. It's giving the case direction. It's putting us at least on the road to a resolution. IT Goatee says Gingras is going to ask for a continuance. Well, we'll read today. He's basically said we need to do this or a continuance. So we'll we'll read the super chats here in a second. But yeah, I am actually honestly very, very grateful that she does have a lawyer who's going to stick with her. Jason Swabby says she had a lawyer. Josh Lopez was there for her when Clayton was still solo, but he's not there anymore. And then she went through a series of them. And I think we've got Gingras is here. Did I say Gringas? Sorry. If I said Gringas, I meant Gingras. David Gingras is here, and he's sticking by her. So whether you think, he said if I find out my client lied or lies to me, I'll immediately drop. Well, for whatever reason, he's sticking with her, and I'm actually happy about that. So we say things in the heat of passion in a moment, but we'll talk more about that when we get into the actual filings themselves. But I just want you to know that I am genuinely happy he's involved and that he is zealously advocating for his client. There certainly can be no complaints about his ability to represent his client from her perspective. And as I've said from day one, I don't know the story. I only know what we're allowed to see and what we're allowed to talk about by either side. Before he got involved, the only information, the only documentation we had regarding her side of the story, and whether you like it or not, whether you agree with it or not, she does have a side of the story. And it's her side of the story to tell. But we didn't have access to that until David Gingras came on board. Everything we saw was from Clayton's side, from the Reddit people who go down to the court and actually get the documents and then upload them to Reddit. We would have access to those, but they wouldn't upload her responses and her submissions. So we had no idea what was going on her side of the fence. Now that David Gingras is here, he is being very, very transparent. what's being filed. He's being very, very vocal in his statements, just like Yoda has decided to use this time now to be vocal for the next couple of minutes. Ignore the dog behind the curtain. But anyway, David Gingras has been very, very transparent, very, very open. He puts every submission that he's able to on his blog. He blogs about it. He responds to chat. He responds to his comments. He is far more transparent than I would be if I was representing her. Right, Yoda? Are you done? Are you done? Seems to be done. So I know a lot of you have very, very strong feelings about David Gingras, but you also have to look at the fact that he has opened this up. He's allowed you all to see what her filings are, and he's taking this 8-lane highway that she's presented before his involvement, and now he's got it down to a good normal sized thoroughfare where we have some direction in the case. We have some definite insight into what her position is and what her arguments may be. So I'm saying we need to actually realize that David Gingras is helping move this thing forward one way or another. And is it, again, going back to the theme that I have no idea what happened. I wasn't there that night. All we knew at the beginning was she claimed to be pregnant with twins, and Clayton said, I only got a blowjob or two out of it. That's all we had to work with. So it was all the insanity. You can't get pregnant from a blowjob, and it was instantly people are heavily on Clayton Echard's side. But now we have to seriously consider the submissions that are being made by her side and reach our own judgment, because none of us were in that house that night. And the very first show we did about this was with Tug and Megan, I believe. That they were the first one. It may have been Dave Neal. It was one way or the other. But Dave Neal was very, very early on in maybe the first or second show we did about this. And I told him, I said, I'm just going to listen to you, Dave, what you know about this and what you tell me. But also, the door is open for her, and I will give her equal time. I will give her equal time to come on my show and tell her story. And I will listen to her in exactly the same way I'm listening to you to get both sides of the story. Of course, that never happened. But now we sort of have the equivalent of that. We have the submissions coming from her side that we're able to see, and we're able to see what her position is. And that's kind of what we're going to be taking a look at here for the rest of the show. The submissions made by her side, the most recent submissions by her side, and the most recent blog post by David Gingras. So let's get into these, and keep an open mind, because this is things the judge has to consider. The judge just can't say, justice for Clayton, forget everything the submit. The judge has to seriously consider everything that is submitted from both sides. And we're gonna talk more about specific arguments and things as we go through and as we read this. But before we do that, let's clear off the super chat board here. Smopo Vienna, member for 11 months. Thank you so much. Say hello to Vienna's newest pallbearers. Did somebody die? Hi. God, I hope nobody died. That's dark. Thanks for 11 months support, Smopo Vienna. I hope everything's okay. Yoink. And Hayden Aussie Overlord with the $5 Australian. Turn your WhatsApp notifications off. The buzzing will annoy chat by the time I'm done with dog pics. Oh no. Well, all right. Better take him seriously. There we go. Thank you, Hayden. Appreciate that. All right. Let's bring up our first document, which was filed at the end of April. Let me share ye oldie screen here. Where is it? There we are. And we'll embiggen it as much as we are able to embiggen. Hey, where'd I go? Hi, there I am. Let's do it properly, shall we? There. Embiggen. Why are you not embiggening? There we are. We are now embiggening. And it looks like that's about as much as we're going to be able to embiggen. Let's see if I can move on over here. And nope. I'm cutting into the meat and potatoes of the we're just gonna have to go back to small me. Hey, going back to small me. Hey, I could be a witness in the Karen Reed trial. Every time I smacking the lips. All right, I digress. I don't want to get far afield today. I don't want to get too far out into La La Land because we have this motion to discuss here. All right. This was filed, I believe, on April 30th. Let's find out. April 30th, yes. Dated April 30th. Kitty says, All right. Bernice Conklin, hi to everyone in the chat. I hope everyone is doing well today. I hope we're doing well today, too. I'm concerned about Smopo Vienna because he says, say hi to Vienna's newest pallbearer. All right. We've got, as we jump into this document, we have concurrently 499 viewers and 288 likes. Hey, that's actually not too bad, but it's still not quite enough. So get down there. We need 200 more likes while I'm reading this. Come on, we can do that. You can do that. It's no problem. And subscribe. Subscriptions are what we're focusing. We need to get to 76,000 subscribers. That'd be cool if you would just hit that subscribe button and double check to make sure you're still subscribed. Now that I got that out of the system, let's get here to the this is in re matter of Laura Owens, petitioner, and Clayton Echard, respondent. In the Maricopa County Superior Court, state of Arizona, this is an emergency motion to strike and request for immediate telephonic scheduling conference. You'll remember he did the what I found to be actually very, very witty and very, very funny motion to compel lunch, which was shut down by the court. The motion was denied, and now he's making the request just for a telephonic scheduling conference. Lunch seems to be optional at this point. Well, Ike, you're just in luck because we're just getting started. We're just getting started with the important stuff. Pursuant to Rule 35A3, Arizona Rules of Family, petitioner Laura Owens, Ms. Owens, or petitioner, respectfully moves the court for an expedited order striking the pleading filed on April 30th, 2024 by respondent Clayton Echard, Mr. Echard, or respondent, entitled Reply to Petitioner's Response to Respondent's Amended Motion for Relief Based on Fraud. So the paper trail here is right there in the title of the document. Clayton's team filed an amended motion for relief based on fraud. They said that the order of protection should be thrown out because it's based on fraud. And they lifted a bunch of areas where they consider that Laura acted fraudulently. And then David Gingras filed the response to the amended motion. And now now's the reply. Follow. This is inception. We've got inception levels here. Respondent files the motion. They file the petitioner's response to the motion. Then Clayton Echard's team, they file the reply to the petitioner's response to their own respondent's amended motion for relief. Now what we've got here is a request to strike that. It basically take that reply to petitioner's response to respondent's amended motion for relief based on fraud and throw it in the garbage. Just get rid of it. It's saying it's a fundamentally flawed document that should just be completely stricken. So we've got the amended motion, the response, the reply, and this is 4 levels deep. I thought it was 5 levels deep. It's only 4 levels deep of responses. Now, separate and apart from that issue, so he's asking for the order to strike the pleading, just throw it in the garbage. MG Law, only 29 minutes into time. Got to pump those numbers up. Those are rookie numbers. No. Now we spent a lot of time talking about the filing of the case and the development of the case and David Gingras and our feelings to him and how we should actually be very thankful he's involved in this at some point. Now we're just getting into the filings. So this is stage 2. We've already completed stage 1 of the evening. We're not that bad. So separate and apart from that issue, Ms. Owens respectfully requests an immediate telephonic scheduling conference pursuant to 76(1)(a) for the purpose of discussing a potential change in trial dates. Based on respondent's recent disclosure of new and untimely information that he has never previously disclosed. So this is what we're hitting in the IT Goatee was talking about. He's saying, look, these are the options we're going to give. Either don't let it in, judge, don't let all this late stuff in, or if you do let it in, we're going to need more time to address it. So it's kind of a toss-up as to what's going on here at this point. He's given that out there. So in addition, at the scheduling conference, Ms. Owens will raise a potential motion in limine seeking to exclude 3 newly disclosed witnesses. We briefly touched on that a while ago. He wants to exclude 3 of the potential witnesses who are the alleged previous victims. He wants them to not be able to testify at the hearing. Now, regarding the reply, the court should strike the reply brief in its entirety on the basis that it grossly violates the plain language of Rule 35A3. That rule provides in all motion practice, the reply may address only those matters raised in the response. So he files the original petition. Then David Gingras files a response. And when Clayton Echard files his reply to the response, Echard's team is only allowed to address those topics that are raised in David Gingras's reply, in his reply. So you can't just start adding new things. If you're replying to someone, you can only work within the limits of what you're being given. So yeah, you can't just stack things on, go, oh, here's some new stuff we want to put in our reply to this guy. So that's what he's saying is happening here. He's saying that he's going to explain why this whole thing should just be thrown out on the basis of he's adding stuff. Now here, Mr. Echard's reply brief violates 35A3 because it contains extensive new allegations and information, which were not raised in either Mrs. Owens' response or in Mr. Echard's original pleading. So yeah, he didn't talk about these things in his original pleadings or his original motions, but now he wants to add it to a response to a reply, and he's saying you can't do that. Specifically, Mr. Echard's original motion sought relief on the basis of fraud because, inter alia, among other things, he claimed that plaintiff was never pregnant by defendant. In addition, the motion argues Ms. Owens committed fraud, intrinsic and extrinsic, when she testified before Judge Duty regarding a sonogram on October 25, 2023, leading Judge Duty to uphold the order of protection. Now, in her response, Ms. Owens directly and properly addressed those specific issues and allegations raised in the original and amended motions. So she's saying, hey, we did our job. We focused on what he put in his original motion. We focused on that. We didn't expand it. Now, in his reply filed earlier today, now I will give Gingras yet more props. He got the reply that day, and in the same day, he was able to crank out and file this a 6-page motion. That's pretty good timing for a lawyer. So kudos to him for doing that all in one day. In her response, Ms. Owens directly and probably, okay, now in his reply filed earlier today, Mr. Echard offers entirely new arguments and evidence, including new evidence literally disclosed for the first time today. Specifically, the reply contains the following new arguments / evidence. So this is what he's arguing is new and improper to put in this reply. An assertion that Ms. Owens fabricated other medical records not previously mentioned in Mr. Echard's original or amended motions, because there was the allegations of fabricated or arts and crafts medical records. He's saying they're coming up with new ones to allege. See reply to 3014, discussing for the first time via medical records from 2016, which are also dubious. Laura claims she had ovarian cancer and that she had an ovary removed, information that is patently missing from any of the medical records provided by Laura. The next item, he says, is new and improper to put in this motion is an assertion that Ms. Owens concealed information from her expert, Dr. Medchill, by failing to disclose a prior cancer diagnosis and removal of her ovary. Something Ms. Owens flatly denies. And we're going to get more into that denial in subsequent motions that we're going to be looking at tonight. See reply to 8 through 14, alleging there is no mention in Ms. Owens' expert report of John Chung Kale Chan, MD's records for Laura, who reportedly diagnosed her with, quote, real ovarian cancer, not something that may just be there. You remember that this type of diagnosis was soundly ridiculed and laughed at by just about everyone. That's not how doctors don't diagnose you with real ovarian cancer, not something that just may be there. The wording of the letter that she needs to convince her boyfriend to help her through these things, it was all soundly ridiculed by myself and just about everybody else that talks about this case. And now Gingras' side is saying those are fabricated. Not by Laura, not by anything, by somebody else. Or Rebecca Yee, MD records for Laura, who said yesterday you received an ovary removal surgery, oophorectomy of your right ovary, as well as a surgical abortion. And the next new example of a new item being put into the improperly, allegedly into Echard's document is an assertion that Ms. Owens fabricated 3 ultrasounds. See reply at 4, 8 through 9, asserting, to be clear, there are 3 ultrasounds that have been altered. 1 image used in the order of protection, current proceeding, and 1 video and 1 21-week sonogram. In addition to these completely new claims and theories, Mr. Echard's motion is supported by dozens of pages of new documents, which he only disclosed for the first time today, October 30th, 2024. Of course, none of this new information was contained in Mr. Echard's original motion for relief based on fraud, nor the amended version of that pleading filed only days ago. Thus, Mr. Owens could not and did not address any of this material in her opposition brief. This is precisely why Rule 35 expressly prohibits this sharp practice of belated sandbagging. Because unless, I have to pause this thing here, okay. Because unless corrected by striking the offending pleadings, Ms. Owens will have no opportunity to address any of the serious allegations which were raised for the first time in her reply. Oh, Nancy Kastner just subscribed. Thank you, Nancy. Thank you so much. Now, this is what he's saying. He's saying we have rules here. And Rule 35 is designed to prevent you from sandbagging, to throw things in at the last minute or to expand on things so that they can't be properly responded to in a timely manner. So he said, if this is allowed to go through, then Ms. Owens isn't going to be able to address any of this material in an opposition brief. And so this is precisely why it prohibits the sandbagging. Because unless corrected by striking the offending plea, unless you throw out all of these improper proceedings, Ms. Owens will have no opportunity to address any of the serious allegations which were raised for the first time in the reply. Now, Mr. Echard's conduct, David Gingras continues, in attempting to raise new issues and new evidence for the first time in his reply is improper and inexcusable. Indeed, the violation is so egregious, it would constitute reversible error standing alone. That's the old proverbial shot across the bow there to the judge. Judge, if you don't listen to me, here's some cases that say if you do this and we lose, it could be reversible error on appeal. So if you don't want to have your judgment overturned by a higher court, we suggest you listen to us. This is a standard classic lawyer shot across the judge's bow. To use maritime technology terminology. So indeed, the violation is so egregious, it would constitute reversible error standing alone. See, this case, reversing judgment on a basis of new trial raised for the first time in a reply. And another case, the moving part, this is citing Arizona Rules of Civil Procedure 7.1A3. The moving party may file a reply memorandum, which may address only those matters raised in the responsive memorandum. So it's pretty clear right there in the Arizona Rules of Civil Procedure that a reply can only contain matters that are raised in the document that you're replying to. Emphasis added. Boulevardier cocktails are really good, by the way. Noting unfairness of considering argument to which opposing party had no opportunity to respond, and another case there. So then we've got another case, noting arguments on appeal first raised in a reply brief improperly deprive opposing party of opportunity to respond. And that's exactly what he's arguing here. Noting arguments on appeal first raised in reply brief improperly deprive opposing party of opportunity to respond. So he's going to explain what all of those judgments and what all of the rules and everything mean. He's going to apply the law to the facts of this case. And I'm cleaning off my glasses because I'm tired of looking around spots and smudges. I apologize here. Well, as long as we're moving into the next part of his brief, let's also, or his motion, let's see what we've got here. We've got a couple of starred items. Blah, blah, blah says, Wiki, Padlet, Reddit posted all motions, not just Greg Woodnick's. The Justice for Clayton Reddit, I don't recall seeing anything that was filed by her. I mean, it may have been there, but I didn't see it. So that's where I'm coming from. Julie O with the $10. Thanks to Flux, I can't see emails at work from anyone named Becky without saying Becky's a hoe name. All right, Julio. Thank you for that. Do we have emails from someone named Becky today? All right. Thank you, blah, 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 and thank you, Julio, for that. Right. So let's get on to the explanation here. Rose leaning over the bow of the Titanic. It's not new evidence either. It kind of seems to be, though. But let's assume it is new evidence. There's a way around this, and we'll talk about that in a minute. Well, sorry, there we go. Yeah, we'll talk about the way around this problem. Flux is lurking. always lurking. All right. Raising new issues for the first time in a reply brief, as Mr. Echard has so clearly done here, is a per se violation of Rule 35. For those reasons, Ms. Owens respectfully moves for an order striking Mr. Echard's reply brief in its entirety. Again, wants the entire thing, his entire motion asking for the order of protection to be thrown out. He wants that motion, just the entire thing, to be chucked in the garbage. In addition, pursuant to Rule 76(1)(a), Ms. Owens requested the court set this matter for an immediate telephonic or in-person scheduling conference. Among other things, the purpose of the scheduling conference will be to discuss whether or not Mr. Echard will be permitted to call several untimely disclosed witnesses. Ms. Owens intends to file a separate motion in limine, which already did, on that issue within the next day. Also, assuming the court does not preclude Mr. Echard from using untimely disclosed witnesses and documents, it may be necessary for Ms. Owens to request a continuance of the trial in order to allow sufficient time to investigate and respond to the new and extremely late disclosures by Mr. Echard. Dated April 30, 2024, David S. Gingras, attorney for petitioner Laura Owens. Now, see, these are often overlooked when we read these motions, but this page here is an incredibly important part of the motion. Pursuant to Rule 9C of the Arizona Rules of Family Litigation Practice, I believe it is, for family law practice, I can't remember what the LP stands for. The undersigned certifies that he has made a good faith attempt to resolve the issues in this motion by consulting with opposing counsel, but those efforts were not successful. Specifically, on April 30th, 2024, the undersigned contacted respondent's counsel via email to request a time to meet and confer regarding the instant motion. Respondent's counsel did not respond to this request, but did indicate via email that respondent disagreed with petitioner's position. And here's the file copies, everything. So that is the first motion. That's the first emergency motion, to throw out Echard's motion and to set an immediate conference between the two parties. We're going to look at the next one, but before we do, my sister just sent me a message. Before we do that, what are you thinking? I mean, there's a lot of people, and I've seen a lot of people, especially on David Gingras's blog and whatnot, going, you're just looking for these technicalities. You don't have any good solid arguments. You're just looking at these like time rules and rules like this. But you know what? This is another thing where rules are there for a reason. Rules are there to be complied with. And you know that if Gingras was missing deadlines, I'm not saying that Echard's lawyer missed any deadlines or whatnot, or did things that aren't in accordance with the rules. Echard's side would be up in arms and would be making the same arguments and would have every right to. Just because something is a technicality doesn't mean you can't argue it. So that's the thing, is like, if when you get after lawyers are easy targets. MG Law says if he really feels he must respond to the new information, then he can file a request for leave to file a SIR reply. There is no impending hearing that would prevent him from filing one. Or the other way out of this, and I was going to address it later because I think David Gingras actually brings it up, would be to go, okay, yeah, you're right. There were some new things in that filing. So I'll tell you what, I'll withdraw that. And here's my new motion to get rid of the order of protection. There's nothing stopping him from filing a new motion based on the new information. So that's one way around it. He could just go, oh yeah, okay, there was some new stuff in there. Sorry, I take that back. Now here's a new motion. And then you lose that argument. I get the feeling Gingras enjoys this like a logic puzzle. Well, again, I mean, you have a lawyer has an arsenal of weapons. You have evidence, you have logic and reasoning, and you have rules. They're all equally valid and viable and usable weapons in your arsenal. And everybody hates it when a lawyer finds a technicality to get a case thrown out or delayed or a piece of evidence hidden until it's your lawyer doing that to somebody else. And then you think, oh yeah, that's the greatest rule ever. So I think we do have to be a little bit fair here and go, yeah, it's not a bad thing that he's using technicalities and arguing violation of rules as a means of forwarding his client's case or prevailing in the matter. It's fair game. If there hasn't been any violation of rules, then the judge will say, sorry, there was no violation of rules and your argument doesn't amount to much. Faulty logic should not be a tool. Well, that's where you hope that your lawyer is more logical than the other guy. MG Login says, I've filed motions to strike before, but only when a response is way out of time or right up against a hearing date. But again, it doesn't preclude him from making this motion right now. So, can't really fault the guy. He is aggressively and zealously advocating for his client. And he has every right. And in fact, he has an obligation to do what he's doing. We may not like the way he does it. You may not like the wording he uses. You may not like his style. But he's doing his job. And speaking of doing their job, let me thank all of you for doing this. I wouldn't be doing my job, which is to entertain you. And are you not entertained? DCV Titan, except isn't all this new stuff brought up in the reply, just pointing out that her records given to an expert are incomplete? Well, that would be one interpretation, and I'm sure David Gingras has another interpretation for it. But yeah, that was the argument, was, it's you forgot to do this, your expert didn't look at this. But David's saying, oh, this is new information. These are new allegations you're bringing up. And the judge is going to sort it out. The judge will sort it out all one way or another. And the judge is the almighty in this case. And so the judge will tell us who is right and who is wrong. And thank you, DCV Titan, for the Canadian 5. And with the US 5, it's Jermaine Down. How are these disclosures extremely late when the due date for all disclosures is May 10th? God, time is going so fast. I don't think it's May 10th. I think it's this Friday. And then I went, oh, holy crap, this Friday is May 10th. Well, this was a week ago. That's what he's arguing. He's arguing they wouldn't have enough time to respond. And I mean, that's, if I was in his shoes, that's exactly the argument I would make. Hey, Strawberry, stop that. Come here. The inappropriate licking must stop amongst the dogs. Come here. Doggy, come here. All right, stay over there, dumbass. I was just going to pet you. If you don't want to be petted, stay over there. All right, I'm back. I mean, this is the same. It's the same argument I would be using. Like, hey, there's only like a week here, and we've got to investigate all of these things. He throws these new medical records we've never seen before, and we've only got about 10 days to research this, find out what happened. We got to find counter evidence. We got to prepare a brief. There's just not time, Judge. That's what I'd be arguing. Thank you, Jermaine. Appreciate that. And Sonia Chris, what's up with the $5? Never mind that she refused to provide disclosure. Again, that's one of the reasons why I'm saying that I am actually happy that David Gingras is involved in this, because we have now had some disclosure from her side, and if he hadn't have been there, I doubt we'd have any of it at this point, and it would be another shit show to deal with. So, hey, let's give 3 cheers to David Gingras for actually getting disclosure out the way it's supposed to be done. So, yeah, I'm not joking when I say I am so happy that she's got a lawyer who is a stickler for the rules and is aggressively and zealously advocating for her. I am genuinely thrilled. Yet now some of you're pointing out, yeah, your client not telling you shit. Oh, that happens all the damn time. Doesn't matter. It just happened to me yesterday in a $5 million case I'm working on. We think we've got everything in a row, and then suddenly our client drops this bombshell that should have been one of the very first things that exited his lips when he entered our office like 2 months ago. It was one of these, all right, everything is here. We've got to do this. And it's like, oh, yeah, well, there's also this. Well, I mean, vaguely how it came out was, okay, we're going to do this, which is going to solve this problem. And it's like, well, what about, well, after that happens, what happens if this new problem happens? And we're like, well, in what realm would that new problem happen? Well, there's this. It's like, what? Why are you just now telling us about this thing that could be a new problem? That happens all the time. And I mean, this is just me. When new clients come to the office, when they're on the defendant side of the table, or when they're on the plaintiff side of the table, we'll be saying, look, if we're your lawyer, if we know everything right now, we can tell you what we can work with. How can we work with the information you give us? We can't, and we can factor in what they're going to say. We're going to factor in what the opponent party is going to say about what we're doing. But if we don't know something that they know or they can find out and they spring it on us, we have no idea how to deal with it, and it throws our plans out of whack. So you try to explain, like, tell us everything right now, so there's no mysteries, no surprises, and no WTF moments further down the line. So yeah, you don't know what your client knows. You have to believe and sincerely hope they're telling you everything and telling everything accurately. I forgot to tell you, we cut a hole in the bottom of the, no, yeah, no. This kind of stuff doesn't happen a lot in the shipping side of things. I'm talking about like the business thing, the contractual sides, the performance of obligations, things like that. Doing it comes up a lot in like corporate law stuff. Where like, you did what? Now, why didn't you tell us this a while ago? But anyway, we've sort of kind of strayed. We've strayed afield. But yeah, I'm happy that he's here and he's keeping there. And all he knows is what his client tells him and what she submits to him, which is why I'm telling you, the guy, David Gingras, has played so many of you like a damn fiddle. He's played you like a violin playing sweet songs. He's used you to formulate a lot of his arguments. In the initial stages, when he didn't have a lot of information, didn't have a lot of insight into what Echard's side may say, he just put it out there on Twitter. And everybody says, oh yeah, but what about this? What about this? And he's, oh, thank you very much. Oh, okay. This is an argument they can make. Let's find out how to deal with this. Oh, here, thank you for telling us about that potential argument. You guys did his work for him. That's why I was saying don't engage with him. If you don't want to help him, don't engage with him, because he's learning far more from you than you learned from him. Trust me on that. So that's interesting. It's interesting because that's how every one of his blog posts was in the early stages. Well, I don't know about that, or I haven't seen that, or we don't know about that. And then 8 or 9 people jump in and very helpfully say, well, on this date this was said, and this date this happened, and everything. Cool, thank you very much. I said don't engage with him. And everybody engaged with him, and now you're grumpy that he's dealing with the information that you gave him. Twitter and his blog was his research team. Anyway, that's neither here nor there. That's all water under the bridge. Let's get to the new motion. But before we do that, speaking of blog posts, let's look at his newest and most recent blog post. Let's see, share screen. We've already done a while ago. Let's talk about lies part 1. This is Let's Talk About Lies part 2. Yes, Flux, we know you engaged with him. MG Law says, that's why I stopped looking at his blog or Twitter. I've tried to only discuss court hearings and pleadings. Yeah, and see, I'm happy we get to see his side of things. I'm happy we get to read this because she does have a side, and this is what we're talking about today. A lot of the things we're dealing with today is her side of the story. And it's going to be up to the judge to decide who's right or wrong. And I've always said from the beginning that if it turns out that this goes in Echard's favor, then we have to assume everything he said was right, and that she is. We have to assume that she is a liar. We have to assume that she is doing all this. But on the flip side, if things go her way, and the judge sides with her, we have to accept her story as true, and we have to start looking at Echard. I mean, if it turns out that somehow it's proven he was the father of twins, fine, so be it. Let the chips fall where they may. That's why we have courts. That's why we have judges, so we can listen to both sides of the story, and juries or judges will tell us what the deal is. MG Law says, but he shouldn't be publishing this stuff from an active case on his website or Twitter. Well, I'm assuming. I mean, I would certainly hope that he's doing this with Laura's approval, and I'm just going to assume there is, because I can't. There's no way that he's doing this without her knowledge and permission. But as I said at the very beginning, he's being way more transparent than I would be if I was in his shoes. So he's got that. I mean, he was being way more transparent than I would be. Well, let's talk about lies part 2, shall we? A while ago, I wrote a post with bullet points that Laura's critics have passed off as truth. Now, we've seen his brief writing, his motion writing, become more professional. We haven't had a hashtag me too, or Trump hasn't been mentioned in a while. No yikes. So his legal writing in his motions have become more and more out in the open. MG Law agrees, says if she can prove she was pregnant and he was the father, then so be it. Right. Can't say as I'm a cult member. I have zero monkeys in the circus. All right, the third point on that list was 3. Clayton says Laura has done this to other men. Now his blog writing is still a little bit confrontational, a little bit biased, a little bit rough around the edges, but we'll make necessary comments as time goes on here. I'm going to skip point 2 for now, and let's talk about point 3. Laura has done this to other men. Sounds bad, right? But is it true? Is it true that she's done this to other men? Let's talk about that. One of the, quote, other men frequently discussed is a guy named Michael Maricini. She calls him Mike, so I'll use that for now. If you have followed the story, you will know the cult claims Laura faked being pregnant. Again, I'm glad he stopped using the Clayton's crazy cult with all K's, with the 3 K's, the KKK. I'm glad he finally stopped doing that. That was good, but still calling it a cult, you know, you don't need to go there. David, I did a whole show on can we raise the level? This instead of trying to resolve things, instead of trying to be more amicable, this just makes it worse. It makes people hate you more, makes you more angry. It gives everybody indigestion, and it's just not necessary. You don't have to call people that disagree with you cult. A lot of people aren't in the cult. Anyway, I don't want to get off on that, but you don't need to call them cult. Come on. You will know the cult claims Laura faked being pregnant with Mike, and every time that story is repeated, it's spoken about as if this is a statement of true facts. Laura lied about Mike's baby. But is it true? Well, before I get into the details, there's something very important you need to understand. Have you ever seen a TV show or a movie about a court case and one of the lawyers jumps up and shouts, "Objection! Foundation!" I just sort of felt like sort of felt like Phoenix Wright there for a minute. Objection! Actually, just to again roam far afield, I've been thinking about doing Phoenix Wright game nights here. If you don't know the Phoenix Wright is a Japanese video game about a lawyer, and you have to make court decisions and whatnot, make objections and stuff. I've been thinking about streaming some Phoenix Wright gameplay. It's okay. The lawyer jumps up and shouts, "Objection, Foundation." Do you know what that means? I'll explain. When a lawyer objects to foundation or lack of foundation, that's our shorthand way of saying we don't believe the witness has been shown to have something called personal knowledge. Okay, what's so special about personal knowledge? And he's absolutely correct here. You can't give, and we've heard, if you've been following the Karen Reed trial, the judge has harped on that a few times. You can't testify to something you did not hear with your own ears or see with your own eyes. And he gives examples of this, so I don't need to. This is law school 101 stuff. But basically, the rules of evidence say a witness can only testify about things if that person first shows they have personal knowledge of the subject matter that they want to discuss. This comes straight from Rule 602 of the Rules of Evidence. The link is for the Arizona rules, but the federal rules are identical. This is the need for personal knowledge. This is the lack of foundation objection. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness's own testimony. This rule does not apply to a witness expert testimony under Rule 703. The text is pretty dry, so let me paraphrase. Witnesses aren't allowed to blow smoke out of their ass. Again, a little unnecessary, a little rough around the edges. If a witness wants to say something is true, they first have to answer one question. How do you know that? Here's an example of how this works in practice. Let's say you're involved in a case and you want to prove it snowed in Hawaii on December 25th, 2023. So you call a witness to the stand and ask them, "Witness, did it snow in Hawaii on December 25th, 2023? If this happened in court, your opposing counsel would immediately object. Why? Lack of foundation. Exactly. We don't know how this witness knows it's you. First of all, you have to tell us why and how this person would have any knowledge of whether or not it snowed in Hawaii on that date. So this is how a lawyer tells the judge, you haven't met the requirements of Rule 602 because you haven't shown that the witness has personal knowledge of this issue. You haven't explained how this person knows that. Mainly, Melissa says, what about her perjurious statements that she only sent the photo to Clayton? Well, I'm sure that is going to be very thoroughly addressed by Clayton Echard's lawyer in his next filing. And he said, this is difficult to watch. Well, law is difficult sometimes because both sides have a right to state their opinion and state their case. We may not like it. We may not agree with it. We may think they're lying. We may think it's fabricated, but each side has the legal right to state their opinions. And that's what David Gingras is doing. He's putting it out there, and we have to consider it. We can formulate our own opinions about it. We can poke holes, as many holes into it as we want, but ultimately it's up for the judge or jury to decide whether they've met their burden of proof. So law is not always a punch and cookies thing. Sometimes it gets a little Jonestown Massacre Kool-Aid in there, and we have problems. So, I would expect a response from Echard's team fairly soon dealing with this. But anyway, let's continue with the blog thing here, with a blog post. And we can't just show one side of the story, because whether you like her or not, agree with her or not, she does have a side of her story. All right, but this problem is easily fixed. So how does this person know that it snowed in Hawaii on December 25, 2023? But this problem is easily fixed. Just like this, before asking anything about the weather, Mr. Witness, were you physically present in the state of Hawaii on December 25th, 2023? And were you in a position to see the weather conditions on that date? I would object that that's a compound question, but that's just me. That's actually two questions. Were you present in Hawaii on December 25th, 2023? Yes or no? And then the next question would be, and if it's yes, were you in a position to see the weather conditions on that date? Assuming the witness says yes, you then ask if they saw any snow in Hawaii on that date. With that simple intro, you satisfied the requirements of Rule 602 by proving the witness was in a position to see the weather in Hawaii. You answered the question, how do you know what the weather was like in Hawaii? This quick little bit of foundation shows the witness has personal knowledge of the weather conditions in Hawaii on the date in question. I know that's boring and technical, but trust me, it matters. And see, we've just gotten a little basic legal lecture in what a foundation objection is. So thank you very much. All right. Chat, you guys are funny. Where do we go here? I know that's boring and technical, but trust me, it matters. Again, this is basic law school 101 level stuff. But if a witness can't show they have personal knowledge of a thing, the witness will not be allowed to testify about that thing, period. I have literally won entire cases based on that one simple rule. All right. As the example shows, establishing personal knowledge is usually not a big deal. If you want to ask a witness about topic X, before you dive into that topic, you just need to lay some foundation showing that the witness has personal knowledge of topic X. It's easy, assuming the witness knows what they're talking about, but most non-lawyers would never think about this. Well, most non-lawyers don't ever have to think about this because they're non-lawyers, and this is things that lawyers worry about and need to be concerned with. And so, well, we'll see where he's going with it. I won't put words into his mouth. We'll let him say what he wants to say here. I'll just provide critique as necessary. Okay, with that boring intro behind us, let's get back to the story of Mike Maricini and why his deposition transcript is so completely devastating for the anti-Laura crew. The full transcript is at the end of this post, but I'll give you a summary. Mike and Laura met through an online dating app in early 2016. He talks about this on page 27 of his depo, and he's not 100% sure of the date or which app, but neither of those points are important. At the time, both Mike and Laura were living in San Francisco. This sounds like a law school problem. This reads exactly like a law school draft test problem. At that time, both Mike and Laura were living in San Francisco. Laura has a freehold estate on Foxacre, and how these things go. At that time, both Mike and Laura were living in San Francisco. Laura has told me she and Mike dated for a couple of years, but the exact start and end dates aren't clear from the records I've seen. For now, just assume this relationship lasted for at least a year, probably a while longer. Basically from early 2016 through late 2017. In mid-2016, Laura got pregnant. This was medically confirmed. This was a medically confirmed pregnancy with multiple records to support it, including HCG tests and an ultrasound. At that time, Mark, I almost said Mark and Lyra. Laura and Mike were both, Luke and Laura. Wow, there's some General Hospital days. Remember, are any of you old enough to remember the Luke and Laura love affair on General Hospital? They're both in their mid-20s. They both felt they were too young to have kids. So they decided abortion was the best option. Bethany is, Katie Buck says, no, I'm a man. Well, I'm a man who had a mother and a sister, so I had to hear all about it. No, he's old. Oh, yes. All right, now we've digressed. We have the Luke and Laura team here. Now, that was the shit. That was the only thing that was talked about on television for a good chunk of years. Anyway. Laura went to Planned Parenthood in July 2016, where she was given mifepristone. She was given a pill to medically terminate the pregnancy. Unfortunately, the first pill didn't work. Not unusual. Yeah. And Laura continued to test positive for pregnancy. This resulted in her going back to Planned Parenthood a few weeks later with Mike. Again, plenty of records exist to support all of this. According to Laura, this was not an issue of her, quote, getting pregnant twice, and certainly not faking pregnancy twice. She got pregnant with Mike once, and it took a couple of doctor's visits to terminate the pregnancy. Mike participated in all of this and was fully aware that Laura was pregnant, and they jointly made the decision to terminate it. Here's a Planned Parenthood record showing the follow-up trip, and Laura also discusses this at length in a declaration I'm adding to the end of this post. Importantly, Laura's declaration was written back in 2018, long before this whole mess with Clayton ever happened. Planned Parenthood, 8/10/2016. Let's see where we're at here. Established patient, counseling, education, comments, ultrasound shows retroverted uterus, tissue remains, blood test shows elevated HCG levels from last visit. Patient took this medicine in the office, instructed to take 800 more misoprostol in 24 hours to evacuate remains. If unsuccessful, D&E to take place at follow-up. Patient instructed to make appointment for following up in 1 week. There's a subjective history. Patient has aspiration abortion 8/2/2016. Also attempted medical abortion twice and says the results were more like spotting than consistent bleeding. Failed abortion. Counseling. Patient maintains that she does not desire pregnancy. Unlike Clayton, the pregnancy and abortion was not the end of Laura's relationship with Mike. They continued dating for many more months. And yes, Laura will admit she struggled with some emotional issues during that time. That's hardly unusual, especially when you understand how Mike treated her. During their relationship, Laura was extremely generous with Mike. She paid to take him to Dubai. She bought him expensive gifts, including a $10,000 watch. She claims Mike even called her his sugar mama. Consenting adults, man, consenting adults. On December 30th, 2016, Laura paid for a trip to Iceland with Mike. Now, see, this is the only real question I have about that trip to Iceland. Why in God's name would you go to Iceland on December 30th? Like, why would you go to one of the coldest places in the world on one of the coldest times of year? Why wouldn't you go to Iceland in like July? That's just something I don't know why, but I really, really, really want to go to Iceland. That's a serious bucket list item for me. But I have zero desire to go there on December 30th. They just wanted to chill there. Nice, Billy Aoki. They just wanted to chill there. It's the off season even for penguins. Penguins don't live in Iceland. All right, tickets are cheap. Yeah, okay. Doesn't seem that way though here. At the end of the post, the Iceland trip cost at least $15,000, and I emptied my childhood savings account to pay for it. I thought she had like $250,000 or 400,000 or $250,000 or 400,000 or something in her part. Anyway, that's not my deal here. She definitely has a type. While Laura and Mike may have looked like a happy couple on the outside, according to Laura, Mike had a very dark and abusive side. In her declaration filed in California back in 2018, Laura described the verbal abuse she received from Mike on the flight back from Iceland. This abuse was witnessed by a fellow passenger, a complete stranger, who later confirmed Laura's version of what occurred. During the flight from San Francisco to Reykjavik, Iceland, Mr. Maracini berated me nonstop for hours. He criticized me for nearly everything I did. If I turned my head to look at him, when he said something, he'd criticize me for turning it too quickly, telling me that my reflexes were unnaturally fast. She moves like the wind itself. That's a weird thing to complain about, seriously, though. If that's true, that's kind of weird. Like someone whips their head. Your reflexes are unnaturally fast, woman. And there was something wrong with me. That's a weird complaint. I'm sorry. It's funny. There's something wrong with you, woman. Your reflexes are unnaturally fast. Seriously, I would have taken that as a compliment too. He criticized my career and told me that I was bad at my job and was worthless. Wow, sounds like my dad. He told me I was ugly and that nobody else would ever want to date me. When I would try to kiss him and cheer him up, he'd tell me I was gross and a bad kisser. He said I was bad in bed. Then he said he wanted to have a threesome since sex with me was boring. He suggested a threesome with my sister or with a black man. He said it would turn him on to watch someone else have sex with me. I told him no, and that I felt uncomfortable. He seemed to enjoy putting me down. His criticisms went on for hours, and I cried on and off throughout the entire flight. After Iceland, according to Laura, things went from bad to worse. According to her sworn declaration in court in California, Mike began physically assaulting her, including strangling her during sex and verbally abusing her. We'll just read the highlighted parts. It's kind of getting icky. Every time we had sex, he strangled me. This happened 4 to 5 times per week, at least 100 times. Sex with Mr. Maracini felt like abuse, not loving and intimate. I often cried while he had sex with me. That's icky. We'll just skip that. Laura eventually ended the relationship with Mike in 2017, late 2017. She claims he began stalking her as a result. Let's see. What do we got here? I saw something here. Tugsim says Gingras has no proof of any of this. Well, these are statements made in court. So, these are statements made under oath and penalty of perjury in court. So he does have that. But, it's just as good as, the integrity of the witness, I guess, is the standard for that. Where'd we go? All right. Continue. Laura eventually entered the case, fearful for her safety. In January 2018, Laura applied for a restraining order against Mike. Here's a complete copy of the file from that case. Hey, Strawberry, are you having fun snoring down there? Now, having said all this, you may be asking yourself, hang on. So Laura claims Mike was an abusive boyfriend. So what? You haven't explained why any of this guarantees a win for Laura. And that's right. I haven't to explain it yet, so I'll do it right now. At the start of this post, I explained the concept and the rule which requires proof a witness has personal knowledge of something before they're allowed to testify about anything. Remember that? Well, now keeping the concept of personal knowledge in mind, go back and read through Mike's deposition. Show me a single example of him offering any explanation to show how he has personal knowledge of Laura faking being pregnant. You can't because it's not there. And FYI, personal knowledge means personal knowledge. Hearing something from a third party is hearsay, not personal knowledge. Again, well, I would say sort of kind of like hearing this from your client. That's kind of hearsay-ish, but tomato, whatever. Whatever's good for the goose ain't necessarily good for the gander, I guess. I don't know. Okay, here we go. Look specifically at his discussion of the pregnancy between pages 45 and 47 of the deposition. As you read this, try to ask yourself, okay, the witness is saying he doesn't think Laura was pregnant, but how does he know that? He doesn't know that. That's why he thinks that. That's where there's a little bit of a disconnect. He doesn't say he knows she was pregnant. He specifically says he doesn't know whether she was pregnant or not, but thinks she wasn't. So that's a little different. Again, that's a disconnect. He doesn't think. He doesn't know. If he knew, he wouldn't say, I think. He'd say she was not pregnant. So, I take issue with the wording of this. I take issue with that. How does he personally know she was not pregnant? He doesn't personally know that. He just said he thinks she wasn't. Remember, a witness can't say it snowed in Hawaii on December 2023 unless they first prove they were in Hawaii on that date. But they can say, I think it snowed on that date, because that's their opinion. It's not admissible in court, but, that's not what we're talking about here. Unless they first prove they were in Hawaii on that date. So again, ask yourself, what proof does Martini have offer to show he peacefully knew Laura lied about being pregnant? Mike is very clear about how he knows that. He does not know that. What? That's a weird sentence. Mike is very clear about how he knows that. He does not know that. He offers nothing but pure speculation. None of this even comes close to clearing the hurdle of personal knowledge. In fact, he even says repeatedly he believes she probably was pregnant the first time. But he apparently forgot the first time was in fact the only time. Maybe he has memory or mental issues. Now, see, Gingras, you don't need to go there accusing him of memory and mental illnesses. Just two wrongs don't make a right. Be better than that. Be above that. Stop the name calling. Be professional, please. Come on, David. But the records on this are clear. Laura was only pregnant once with Mike, but she had to go back a couple of times after the pills didn't work the first time. That's probably why Mike thinks it was 2 pregnancies. It wasn't. It was just one. And in his own words, Mike admits he thought she probably was pregnant. Oops. I'm afraid I don't see the oops there. Aussie Just Jen raises an interesting question. Then why is he worried about Mike testifying in court? Well, it's a very good question. It could be, and get him there and then run him through all of the objection foundations you're talking about. That's one way of dealing with it. Just objection foundation for everything. And the judge will decide if there is a foundation for it or not. Folks, it doesn't get much clearer than that. Mike doesn't have personal knowledge of anything regarding Laura faking a pregnancy. If he tried to say that at trial in our case, I'd object to a lack of foundation. We'll do it. And separately, that he's just speculating about this. If Mike suddenly develops a shocking new level of clarity about this, I hope he can explain why he answered differently in his deposition 6 years ago. Note, Laura informs me Mike's story about her father somehow admitting Laura lied about being pregnant is also 100% false. I haven't met Laura's dad yet, but I'll go ahead and verify his side of things as soon as I can. But if the evidence stays this way moving forward, Laura's critics are going to have a very, very hard time avoiding liability for defamation. Stop with the threats against people, David, please. Come on. Now, see, let's read a little bit of this. I mean, it's unnecessary to make these defamation threats and things. Just come on, David, better. He's highlighted some things here. I don't think this is weird because what he just posts is exactly contrary to what he just wrote. He says, Mike might have mental illness, mental problems because he thinks she was pregnant twice. And he thinks she was pregnant the first time. But then if we read this, it says kind of the opposite. Okay, so Laura, I'm not clear about it. Is it your position that she wasn't actually pregnant? Mike says, I don't think she was pregnant 2 times. He didn't highlight that part. I don't think she was pregnant 2 times. I think one of them was a made-up story. And I think one might have been legitimate. So he's saying she was only pregnant once and she lied about one. But this actually is a tomato thing. But anyway, which do you think was legitimate the first time? And why do you think she was pregnant? So I think she'd just keep me around. Maybe on the first go around. I don't know. I still to this day don't think she was pregnant. He doesn't highlight that. This is him saying, I still to this day don't think she was pregnant. He doesn't believe she was pregnant at all, let alone twice, like Gingras says. So I'm going to call David out for kind of misrepresenting things here. He says, I still to this day don't think she was pregnant. So you don't think she was pregnant at all? And this is the part he highlighted. I don't think she was pregnant because of all the stories. The timelines never made sense. So looking back at the time, I definitely thought she was pregnant. Now looking back, I don't. Okay, so I just want to be 100% because I thought earlier you said you did think she was pregnant one of those times. So is your story that you don't think she was ever pregnant? If she was ever pregnant, I believe it was the first time, but looking back now, I don't know if she was ever pregnant. I don't know how to give you a clear answer on this because at the time I thought she was both times because I'm not going to go study the timelines of pregnancies and do everything like that. But looking back now, I think one of the pregnancies or both were made up. So that kind of goes against what he said. He misrepresented that. And that's bad form, David. You did misrepresent what Mike said. I'll just leave it at that. I feel that was a pretty serious misrepresentation of what was said by Mike in the deposition. All right, we can close that out now. And before we get into this why isn't that clicking? There we go. What's this? We need to go over here. Boop. We're going to read this. This is a relatively short document, and then Laura's affidavit, and we should be done. So this is essentially a supplement to what we just read, the motion we just read. But before we do that, we do have a couple of things to talk about here. DCV Titan with the $2 Canadian from a while ago. Phoenix Wright gameplay with voice acting. I would probably just use the original, objection kind of stuff. The original voice overacting thing. I'll think about it. Sonny or Chris with the $2 keywords. She asserts. Those are the keywords, aren't they? Julie O with a strong opinion of $5 strong opinion. This is called gaslighting. Mike didn't know what was up because she's a professional gaslighter, just like Clayton being confused. Well, Julio, that certainly is a strong opinion you have there. It seems to be shared with a lot of people. I for one am glad this is going to be settled by a judge once and for all. Hopefully at the June 10th hearing or shortly thereafter, and not after several more delays. Thank you so much for your $5 opinion, Julio. Your support is incredible. How you been anyway, Julio? Your support is awesome. Oh my God, Joe Choi says I didn't hit like. Don't be a Joe. Everybody should be a Joe. You're awesome, Joe. Just be a more mindful Joe. And well, let's lose this. Let's use this opportunity here to say we have 672 concurrent viewers and 537 likes. That's a pretty damn good average there. but we still have some ground to cover. We need 150 of you to get down there and hit that like button. That would be super, super awesome. And additionally, what we need is we need you to check and make sure you're subscribed. We're now at 75,665 subscribers. We're now 35 subscribers away from 75,700. We need to get up to 75,700. I just need 35 of you that haven't subscribed to the channel to go down there and hit that subscribe button so you can come back and you can check all of our comments, our commentary and opinions on all of the Laura Owens matter and all of the Karen Reed trial we're following. We're going to be doing that live tomorrow, as well as an update from today. And our panel shows that we're going to be doing on Friday, Maritime Monday. We do stuff about the maritime industry and ship collisions and cannibalism and horrible things like that. We do retro trials. We talk about all kinds of fun stuff here. And you want to be part of it. I know you want to be part of it. Get down there and hit that subscribe button. And if you have subscribed and if you know you've subscribed, please just double check to make sure you're still subscribed, because YouTube likes to unsubscribe people randomly, and we need to fight the YouTube power. All right, we just got 5 more subscribers. Cool. We are exactly 30 away from hitting 75,700. That's really cool. Thank you so much, people, for the continued support. Let's help this channel grow. I need a silver 100,000 subscriber play button right back there. It'll be prominently displayed if we ever get there. All right, let's look at this new support. This is a reply in support of the emergency motion to strike and request immediate telephonic scheduling conference. Okay. Filing here by David Gingras. This was filed, I believe, on May 3rd. Double check. Yes, May 3rd. This was filed on May 3rd. Sort of a supplement to the last motion we just read in light of new developments. And I'm looking at you people, checking to make sure you're still hitting that subscribe. Oh, we forgot to check our like and subscribe poll, didn't we? Let's quickly check in on our like and subscribe poll. How do you want this case to end? Bush McFadden, did you watch Stormy Daniels' testimony? Nope. I just couldn't care less about politics. Like, subscribe, and vote. How do you want this case to end? 83% of you have said you want it to end in mass destruction and scorched earth. Oh, my disobedient children, have I taught you nothing? Have I taught you nothing about charity, sympathy, and caring for your fellow mankind? Only 6% of you want everybody to just drop it and walk away. But only 5% of you say, can't we all just get along? And 6% of you only say, just hugs for everybody. People, why do you want the scorched earth? In a scorched earth policy, everybody loses. Even if you win, you lose. There's got to be a better way out of this. There's got to be a better way where we can go, all right, let's all just be rational adults and find a nice way out of this for everybody. Preston 8, Jeff is too optimistic about the antagonist involved. Well, one man's terrorist is another man's freedom fighter, as the saying goes. My voice is getting dry. Hang on. Thank you very much for sticking around while I consume this amazing Boulevardier cocktail that I made myself. And it's an hour and 20 wow, it's an hour and 40 minutes and we still have ice in there. That's very nice. Being rational in this case just don't go together. Come on, people. All right. This is David Gingras' filing again here. Most recent filing, May 3rd. This case is quickly spiraling out of control into an unwieldy, confusing mess. Truer words have not been spoken, I believe. This I will concur with that statement. This is spiraling out of control into an unwieldy, confusing mess. The purpose of the present motion is to stop this and to help restore some order to the proceedings. Well, that's very nice of David Gingras. He's wanting to put this thing back on track, wanting to, as Susan Powder said, if you're old enough to remember the Susan Powder commercials, stop the insanity. In short, all Ms. Owens asks is that Mr. Echard follow the rules of procedure because he has not done so. Again, all right, everybody's hackles are raising. I can feel the hair on the back of everyone's neck standing up. I can feel the foam starting at the corners of your mouth. He has every right to complain about not following the rules if the rules aren't being followed. We talked about this at a length earlier on in the show. That is a weapon in his arsenal, and he better use it if it's available to him. That's all I'm going to say about that. This is a valid weapon of choice. Procedural errors, technicalities. As I said, everybody hates it when a lawyer uses technicalities until your lawyer uses a technicality to do something on your behalf. Then it's like, hey, that was clever of you. Wow, that is so cool. You knew about that technicality. It just depends on which side you're on, the receiver or the receivee of these things, the giver or the receiver of technicalities. In short, Ms. Owens asked Mr. Echard to follow the rules of procedure because he has not done so. Well, let's find out. The court should strike his reply filed April 30th, 2024 in support of his motion for relief based on fraud. In addition, the court should set an immediate Rule 76.1 scheduling conference to permit the parties to discuss the implications of newly and untimely disclosed evidence from Mr. Echard, evidence which Ms. Owens claims is false and wholly fabricated. Both of these things, striking and replying, and holding a scheduling conference, are needed to ensure this case stays on track rather than flying off the rails. We don't want this to fly off the rails. We're on crazy train. Introduction to recap. Let's take a recap here. To recap what's going on in Crazy Train. The issue for the court is very simple. Does Mr. Echard's reply brief contain new material that goes beyond the scope of Ms. Owens' response? Renee, you're funny. Does this go beyond the scope of Ms. Owens' response? If so, that material should be stricken. Before explaining why the reply should be stricken, it's important to understand the posture in which Mr. Echard's motion for relief arose. On March 25, 2024, Mr. Echard filed a motion in the companion case, the Order for Protection matter, the OOP case. In that motion, Mr. Echard asked for relief from the order of protection obtained by Ms. Owens on the basis of fraud. That same day, Mr. Echard filed a motion in this case, the paternity matter. Because again, there's two separate deals. There's the order of protection matter and the paternity matter. And there's recently been, this is it. They're now going to be heard at the same hearing. That same day filed a motion in this case, the paternity matter, asking for a joint hearing on the OOP motion for relief. The court granted this request for a joint hearing in a minute entry order dated April 26, 2024. Thus, Mr. Echard's motion for relief is now effectively before this court. So she's taking jurisdiction over both of these, and the hearing on June 10th will be for the order of protection and for the paternity matter, or what's left of the paternity matter, I should say. Notably and importantly, more than a month after it was filed, Mr. Echard's initial motion for relief was amended on April 26, 2024. Footnote 1. For context, what the court may not understand is why the motion for relief was amended. In the second paragraph, the amended motion suggests this motion is amended solely in an effort to streamline litigation and focus on the upcoming trial. That explanation, which is inaccurate and misleading at best, fails to explain what actually occurred. Specifically, after undersigned counsel was retained, it quickly became clear the motion for relief contained numerous false statements of fact, which appeared to violate Rule 26b-3. While a full discussion of these matters is beyond the scope of this brief, one key... while the subject of that dispute is beyond the scope of this brief, let me tell you about it anyway. This part here does not need to be in. It's not important, and we shouldn't talk about it, but let's talk about it anyway. Right here. One key issue was Mr. Echard's representation to the court that to date, every obstetrician and gynecologist have indicated they have no, there's a very important part left out there, have indicated they have no records as she was never seen to be a patient. That representation was and is entirely factually false. Based on this, as required by Rule 226C2B, the undersigned sent a letter to Mr. Echard's counsel demanding the motion for relief be either withdrawn or amended within 10 days, and that if no action was taken, Ms. Owens would seek sanctions under Rule 26, rather than facing sanctions for making a false statement to the court. Mr. Echard amended the motion for relief. It's how you spin it, kind of, though, isn't it? While such an amendment is permitted by the rules, it is worth noting this decision was essentially an admission by Mr. Echard that his original motion did contain false statements, some but not all of which were removed in the amended version. Yeah. Got thoughts about that, but I'll keep them to myself for now. Linda Ever says, no lying about cancer now. She has cancer survivors disliking her tremendously. Well, he's going to explain why she's not lying about cancer. He's going to clarify that for us in this motion. He's going to explain why she never claimed to have cancer. So sit back and enjoy the ride while we hear why she never said she had cancer. Michael Berg, and I'm going to put in a cool footnote, like in law school. I was actually criticized by a few professors because I refused to use footnotes by and large. I said, look, if it's not good enough to put in the body of the document, it doesn't need to be there. And that's and I've always held that. I fucking hate footnotes. I hate them. If it's not important enough to put in the main body, it doesn't need to be in there. Don't put it in there. Now, citations are a different matter. But these explanatory, these narrative footnotes, nope. If it's not important or direct or relevant enough to put in the body, don't make footnotes. I've just always said that. And like I said, I had a couple of law professors that would freak out at me because I wasn't using footnotes. I'm like, I don't need them. Anyway, sorry, trauma. That's trauma from 29, 30 years ago. I can deal with it. 4 days later, okay, here we are. After the motion was amended on April 26, 2024, Ms. Owens filed a response later that same day. 4 days later, on April 30th, 2024, Mr. Echard filed a reply in support of his amended motion. In that reply, Mr. Echard raised new arguments based on new evidence, which was neither mentioned in his original motion nor disclosed prior to that date. Ms. Owens now moves to strike this new information on the basis it violates Rule 35A3. Well, here's the discussion on this. Let's discuss amongst ourselves. Mr. Echard's reply contains new evidence arguments not present in his original or amended motions. As explained in the motion to strike, the new information contained in Mr. Echard's reply includes an allegation that Ms. Owens lied to her own expert, Dr. Medchill. And I'll tell you, I still think it's like the coolest thing ever that there's like some ancient retired doctor whose name is Medchill. So it sounds like somebody who should be like out in the Nevada desert, like, you know, promoting pharmaceuticals, you know, like mushrooms or something. He's like, I am Dr. Medchill. Partake of psilocybin. That kind of thing. I think it's like Dr. Medchill is like the coolest name for an old doctor ever. Dr. Medchill. Okay, there's accusations and allegations that Ms. Owens lied to her own expert, Dr. Medchill, by withholding medical records showing she previously had ovarian cancer, and that as a result of that cancer, one of her ovaries was surgically removed. To support this claim, Mr. Echard's reply purports to quote new medical records, literally disclosed by Mr. Echard the same day as his reply from a doctor named John Chung Kale Chan. Mr. Echard claims these new records somehow separately support relief on the basis of fraud because there's no mention of John Chung Kale Chan's MD's records for Laura, who reportedly diagnosed her with, quote, real ovarian cancer, not something that just may be there, or Rebecca Yee, MD's records for Laura, who said yesterday, 8/30/16, you received an ovary removal surgery, oophorectomy of your right ovary, as well as a surgical abortion. Reply ISO amended. Now, okay, so this is the allegations that he's saying Clayton is making, and he's going to address them right promptly with his response here. Despite quoting from these records in his reply, which Mr. Echard disclosed as part of his 7th supplemental disclosure statement dated April 30th, the actual records were not attached to the reply. Accordingly, to help illustrate the problem, one of these newly disclosed records is shown below. Wow, strawberry snoring up a storm. Remind me to show you all the AI I've been getting of my dogs wearing CPAP gear. This is 830 Owens, name, Laura M. Owens, date of birth, PCP, John Chung Kai Chan. Why do they keep calling him Kyle when it says Kai here? John Chung Kai Chan, MD. To Laura M. Owens from Rebecca E. MD. Yesterday, you received an ovary removal surgery, oophorectomy, on your right ovary, as well as a surgical abortion. Due to your recent medical history, I will wait to confirm pregnancy termination until blood work and a follow-up ultrasound are completed, although there was no complications during this procedure. As you explained to me, you have already experienced emotional side effects such as extreme fatigue, depression, and mood swings. These are common, and I would ask your boyfriend to support you during recovery. We all ridiculed this soundly because this sounds like something like the weirdest thing that a doctor would never, ever say. This is just a weird sounding thing, and it was ridiculed roundly and soundly by most of the people that saw it. Mr. Echard claims this new evidence shows Ms. Owens lied to Dr. Medchill by failing to disclose her history of ovarian cancer, but therein lies the problem. Here's the explanation, people. Here's the clarification. Ms. Owens never disclosed this information to Dr. Medchill because this record is 100% fake. Ms. Owens has never had ovarian cancer, nor has she had an ovary removed. That's the explanation. Not only were myself and Tug and Megan and others soundly ridiculing this, David Gingras and Laura Owens are also soundly ridiculing this document because according to David Gingras, this document is 100% fake. Laura Owens has never personally claimed she had ovarian cancer. It's fake because of this faking fake document. There, that's solved. Right? Right? Well, let's continue. Yeah, this record is 100% fake. Ms. Owens has never had ovarian cancer, nor has she had an ovary removed. To eliminate any doubt on this issue, submitted herewith is an affidavit from Ms. Owens, in which she avows unequivocally the following points. The records disclosed by Mr. Echard as part of his 7th supplemental disclosure statement are fake, false, and fraudulent. These are not Ms. Owens' records. Ms. Owens did not create these faked records and does not know who did. They're faked, and she didn't do it. She has no clue who did it, but it wasn't her, and those are not her records, and those are not her documents, and she was never diagnosed with ovarian cancer and never had an ovary removed. Ms. Owens has never had ovarian cancer and has never had an ovary removed. Ms. Owens was previously diagnosed with polycystic ovary syndrome, PCOS, and in June 2022, she underwent a pelvic CT scan, which confirmed both the existence of PCOS and the presence of both ovaries. Ms. Owens disclosed the PCOS diagnosis to her expert, Dr. Medchill, along with medical records confirming the presence of both ovaries. So here she's saying, I didn't lie. I did not lie to my expert. I gave him the documents that showed I have 2 ovaries because I got 2 ovaries. I've never had ovarian cancer and I've never had one of my ovaries removed. So Ms. Owens did not disclose the existence of a prior ovarian cancer diagnosis because that diagnosis never happened. So there you go. Given that information, the problem should be clear. I hope that clears it up for all of you because David Gingras has explained his client's position and the fact that she does have 2 ovaries and she's never had ovarian cancer and those documents are fake. Mr. Echard has asked this court for relief on the basis of fraud, but rather than playing by the rules and giving Ms. Owens fair notice of his allegations and a fair chance to respond to those claims, Mr. Echard did precisely what the rules forbid. He tried to sneak new and previously undisclosed information and allegations into a reply brief. I don't think he tried to sneak it in. It was kind of the main part of the most recent submission. He apparently just doesn't think it violates this rule, I guess. I don't want to put words into his mouth either. And Henrietta Vandersloot says, oh, well, okay, it all makes sense now. Thanks, David. To paraphrase Henrietta. So, yes. In doing so, Mr. Echard not only violated Rule 35A3, he violated one of the most fundamental rules of basic fairness in litigation. To be clear, Ms. Owens is not claiming Mr. Echard or his counsel fabricated these fake records, although at this point she cannot rule that out. Again, that is an uncalled for, unprofessional, unwarranted statement. To say, yeah, we're not saying he did it, but we're not saying he didn't do it either. Yeah, that's unnecessary. That serves no purpose other than to be a dick, and don't be a dick in your legal proceedings. If the judge thinks that, the judge will think it. She doesn't need you to say it parenthetically. So to be clear, Ms. Owens is not claiming that Mr. Echard or his counsel fabricated these records, but they ain't saying they didn't do it neither. But this lack of clarity is exactly the point. Ms. Owens has no idea what these records are, how Mr. Echard obtained them, and or who originally created them. Lost-plaining to the rescue. We've got lost-plaining. Lost-plaining incoming. Hey, they're rules.
Am I the only one around here who gives a shit about the rules?
This isn't Vietnam. They're rules. Ms. Owens has no idea what these records are, how Mr. Echard obtained them, and who originally created them. Ms. Owens has none of that information because these records were disclosed for the first time in a reply brief, and because Mr. Echard failed to timely disclose this information as required by Rule 49B2B, requiring supplemental disclosures be made in a timely manner, but in no event more than 30 days after the information is discovered by or revealed to the disclosing party. Whoa, we have to stop here because we have an important development. Ladies and gentlemen, Wendy Bono has gifted 5 Legal Vices memberships. If you are Denise Sells, O2 Low, Mangs, hey Mangs, Zutu Fanthrax, and Octovia, make sure you give Wendy Bono a super special thanks for gifting you a Legal Vices membership. We just did a brief membership members only stream last Sunday from the campground I was staying at, so the audio is pretty shit, but we did it. We talked for an hour. She doesn't say she denies sending fake records. Okay, well, you know. Except David Neal has literally just released the forensics on that laptop with the cancer letters, and it's all from Laura. Imagine that. Ooh, well, we'll have to see. We'll have to see if Clayton's lawyer brings that up in court. But for now, David Gingras and Laura Owens have given their explanation, and that explanation is as unyet challenged in a court of law. So we must give it the weight it deserves until it's proven not to have weight. And I'll let you decide what degree of weight it deserves to be given in the first place. In any normal case, investigating this strange new development would be fairly easy. Undersigned counsel would simply pick up the phone and call Mr. Echard's counsel to ask where these new records came from and what, if anything, David, please, for the love of God, don't use what, if any, anymore. Ever. Never, ever use what, if anything. I'm gonna even redact that from your brief here, from your motion. Mr. Echard's counsel seeks Mr. Counsel, rewind here. Undersigned counsel would simply pick up the phone to call Mr. Echard's counsel to ask where these new records came from and what Mr. Echard intends to do with them. But as explained in other pleadings, Ms. Owens' motion to compel lunch, which is still a funny thing. It's weird, but it's funny. This normal dialogue is impossible. This is so because Mr. Echard's counsel has continued refusing to speak to the undersigned by phone for weeks, which severely restricts any collaborative discussion. Unfortunately, this court declined to require Mr. Echard's counsel. Unfortunately, the court said, denied, sit down. This court declined to require Mr. Echard's counsel to speak with the undersigned, leaving the severe communication problem unresolved. Well, for each of these reasons, it is fundamentally unfair and improper to permit Mr. Echard to engage in the obvious act of sandbagging. What have I done? I've touched things. I've touched the wrong things. There we go. I'm trying to organize my screen here, and I touched the wrong thing. Okay, severe communication problem unresolved. For each of these reasons, it is fundamentally unfair and improper to permit Mr. Echard to engage in obvious acts of sandbagging. Mr. Echard's actions violate the rules of motion practice, and his failure to disclose this information in a timely manner violates the rules of disclosure. Taken as a whole, Mr. Echard's conduct also violates the most basic principles of due process, the idea of fair notice and a reasonable opportunity to be heard. So now the question for the court is easy to see. What should be done about this? There are really only two options. The first and most obvious choice, these are the two options I was just talking about just a minute ago. There are ways around this. The first and most obvious choice is to require Mr. Echard to follow the rules. Ouch, that hurt my ear. That was the wrong button. I forgot I changed the screen. Anyway. Ow, that was loud. There are only two options. The first and most obvious choice is to require Mr. Echard to follow the rules. This means the court should strike the reply, should take his reply, should take Echard's reply and throw it in the garbage on the basis that it violates Rule 35A3, and furthermore on the basis the information contained in the motion was not timely disclosed under 49B2B. Of course, that may not permanently resolve the problem. Here's the workaround. Mr. Echard may still choose to bring a new motion for relief under Rule 85B2 on the basis of newly discovered evidence. So that's what I was talking about. He can say, all right, yeah, fine. It shouldn't have been in there, but here's my new motion based on the newly discovered evidence, based on these same fake records. Alternatively, even if he does not bring a separate motion seeking to place these new fake records before the court, presumably Mr. Echard may still attempt to offer them at trial. Now, under these circumstances, to ensure a permanent solution, permanent being italicized, at least he didn't bring up the crazy Clayton cult all in K's and talk about a final solution. That would be a step too far. Under these circumstances, to ensure a permanent solution, the court should immediately set this matter for a scheduling conference for the purpose of asking Mr. Echard to explain his intentions regarding this record. So he's saying, let's bring us all together, schedule a conference, and ask him what's he going to do about this rule violation. Are you going to refile? Are you going to do something else? Or are you going to forget about it? Are you going to strike it? What are you going to do so that we know how to move forward? Now, depending on his position, Ms. Owens must have a fair chance to respond, which may include seeking a continuance of the current trial date. To avoid confusion, Ms. Owens' position is as follows. As explained in the motion in limine filed on April 30th, 2024, Mr. Echard is trying to establish Ms. Owens' guilt in this case by offering prior acts or propensity evidence from previous relationships. And these newly disclosed records, while fake, relate only to the same argument, i.e. proof of prior acts. Evidence from Ms. Owens' past relationships is simply inadmissible in this case under Rule 404B, and also because it is entirely irrelevant. For those reasons, among others, including the fact this evidence was not timely disclosed, the best solution is for the court to preclude this evidence in its entirety. The best solution is just to chuck it out, throw in the garbage, 86 it. If the court agrees with that view, Ms. Owens would be fully prepared for this case to proceed at trial on June 10th. On the other hand, little Miss Judge, if the court is inclined to allow Mr. Echard to use evidence of alleged prior acts, including fake medical records disclosed by Mr. Echard for the first time just days before the existing disclosure cutoff, Ms. Owens must be allowed a full and fair opportunity to investigate, perform discovery, and develop a full response. That would necessarily require continuing the trial date by at least 60 to 90 days. Ms. Owens does not want to move the current date, but it may be unavoidable depending on how far afield Mr. Echard is allowed to go with respect to evidence of Ms. Owens' past relationships. That is why a scheduling conference is so clearly necessary. Conclusion. For the reasons stated above, the court should strike the reply filed by Mr. Echard on April 30, 2024, in support of his amended motion for relief based on fraud. In addition, pursuant to Rule 76(1)A, the court should set this matter for an immediate scheduling conference at its earliest possible date to formulate a plan for trial, including procedures for facilitating the admission of evidence. David Gingras. Wait, where are we? David Gingras, attorney for petitioner. Original file copy sent to Greg Woodnick and signed again. Right. Well, that puts us where we need to be. Unfortunately, it's late. We've gone over, and we didn't have time to get to Laura's affidavit. Let's see. All right, we won't read. Okay, we'll read the affidavit, but we won't read the attachments. So we'll get through this here because it's very, very brief. It's 2 pages and an attachment. So all right, we'll do that because should shut it down, but don't want to shortchange you here. And again, thank you, Wendy Bona, for the 5 gifted memberships, and DCV Titan with a $5 Canadian. I give her evidence all the weight of element 0 from Mass Effect. For those that don't know, its mass is 0 and reduces mass of other elements. Oh, that was such a good series. Why did they have to ruin it? Love that. That's some of my most favorite games, the first 3 Mass Effects. All right. Let's get rid of that. Thank you again very, very much for that comment and for the support. Chat, how you doing over here? I've ignored you, chat. I hate these super long reading intensive things because I don't get to spend much time with chat. You guys, I know you guys don't give a shit what I'm talking about, but you're just talking amongst yourselves. But anywho. All right, let's read her affidavit in support of the motion we just read. This is her very own words right here, sworn under perjury. Let's read it, shall we? I'm sure you're curious to hear the latest affidavit, hear more of her explanations. What have we done here again? There we go. I tried doing big. My screen is flipping out here. All right, there we go. One more. No, that's it. All righty. Very lengthy document here. Flux, just stay awake. It's all night now. It's not fine. Affidavit for Laura Owens in support of her reply in support of emergency motion to strike and request for immediate telephonic scheduling conference. My name is Laura Owens. Hi, Laura. My name is Laura Owens. If called to testify in court, I could and would testify to the following under penalty of perjury based on my own personal knowledge. So again, a statement under under oath, under threat of perjury. I am aware that on April 30th, 2024, counsel for respondent Clayton Echard served a document entitled Respondent 7 Supplemental Disclosure Statement. Among other things attached to Mr. Echard's supplemental disclosure statement were certain documents which purport to be my medical records. For purposes of clarity, copies of the records are attached here to as Exhibit A. Under penalty of perjury, I swear each of the following things are true. Under penalty of perjury, she swears each of the following things are true. The records attached here to it, Exhibit A, are fake. These are not my medical records. Do you guys agree with that or not? I have never had, nor have I ever claimed to have ovarian cancer. Do you agree with that or not? I have never had, nor have I ever claimed to have an ovary removed. Do you agree with that? Many years ago, I was diagnosed with polycystic ovary syndrome, PCOS. I received treatment for my PCOS symptoms, including a pelvic CT scan performed at the Scottsdale Medical Imaging on June 7th, 2022. Do you believe that? Among other things, when I retained Dr. Michael Medchill, as an expert in this matter, I provided him with true and correct copies of certain medical records, which are identified in and attached to his expert report in this matter. Among those records was a report from Scottsdale Medical Imaging shown below, which confirmed the presence of bilateral ovarian cysts during my scan on June 7, 2022, which confirms I still have both my ovaries. And here is the Smile Southwest Medical Imaging report. Uterus is present, bilateral ovarian cysts, and follicles are seen with some complex heterogeneous components in the left ovary measuring up to 5.1 centimeters. No ingenial abnormalities or hernia identified. Increased colonic stool burden of the pelvis. I have no idea who created these fake records attached here to as Exhibit A. All I can say is I did not create them. I have no idea who did, and I never sent them to anyone else because I have never seen these documents prior to them being disclosed by Mr. Echard on April 30th, 2024. Pursuant to 28 U.S.C. 1746, I declare under penalty of perjury under the laws of the United States of America that the foregoing is true. Now, I know some of you are saying that this idea that she never sent them to anyone else may not be true, but she's sworn under penalty of perjury that it is in fact true. And we'll have to see if Clayton Echard's lawyer has any response or any comeback to that or any evidence to support an assertion to the contrary. Yeah, MG Law, I'm not going to read that. All right. That is her affidavit. We got the supporting documents down here. We might be able to look at them at some other time. Now, next time we cover this topic, I do want to continue looking at their submissions and look at their expert report, Dr. Medchill's report, because I still haven't looked at it. We ran out of time again, dagnabbit. All right, people. That's it for today. Again, the purpose of today is equal time, man. She's making submissions. She's making explanations. She's giving affidavits. Her lawyer's making his motions. It's not just a one-sided thing where Clayton throws up evidence and everybody goes, "Aha! See, she's a liar." She gets to tell us her story too. She gets to give us her submissions, and we get to consider it. We get to have our opinions on what weight to give the documents, but ultimately, it's the court that's going to decide who is more credible, who is more reliable, because these are diametrically opposed statements. One party is telling the truth, the other party's lying. And frankly, I don't give a flying fuck which side it is. I just want the truth to come out. I want the judge to tell us who, in her opinion, is the party that's telling the truth. Let the chips fall where they may. So I am equally interested, if not more so, I'm probably more interested in her submissions than in Clayton's submissions at this point, because we pretty much know what Clayton's side is saying. But her side still tends to be a little bit of a mystery. So I'm probably more interested in her submissions at this point. Equality, yes, you are late. We're just winding down. So I want to give a super special thanks to, we had over 700 people at one point. We're down to 555 as people bail on us. But don't bail, because we're going to send you somewhere interesting and exciting, but I don't know where that is right now. But by the way, continue to hit that like and subscribe button. We are 20 subscribers away from 75,700. We're now at 680. 20 more subscribers get us to 700. So if you have it in your heart to subscribe to the channel and continue to follow along with this case and other cases, hit that subscribe button. Hit it. And hit the like button. How are we doing on likes? I haven't checked our likes for a bit. 638 likes. Cool. All right. I am now going to look for some place to send us. It's going to be to the Karen Reed trial. It's just where we're going to go. Let's see. Edit this stream. Go to customization. Go to redirect. And currently potentially criminal. We're going to go to potentially criminal Sean. He's following it. Let's do that. Potentially criminal Sean is following this live, so we'll go to him. All right, people, let's wind this down real quick here. Again, thank you so much for joining me as we look at the submissions and explanations and clarifications offered by Laura Owens' lawyer, David Gingras, who, again, I'm thrilled is part of this now. I'm thrilled we've got some forward motion. Let's see what Clayton Echard's response to this is in due course, and what the judge is going to have to say about all of this. We'll find out how it goes. I want to give a super special shout out to the mods, and thank you so much for being super moddy and being here. Yes, we are going to. Sean is covering too. Yes, we are going to go over to potentially criminal. I saw him first. He was the first one to pop up on my forward list, on my rating list. So thank you, mods, for being here and doing your moddy best. Thank you, chat, for being here, for keeping each other company while I'm lost in reading land. And thank you so much for the memberships, the gifted memberships, the purchase memberships, the monthly membership chats, the super chats, and all that support. Let's keep it going. Let's continue to move forward and get that 100,000 subscriber play button back there. Now, tomorrow we will be covering the Karen Reed trial live. It's a half day on Thursday. We'll be covering that live. Come back here for that. Friday will be our, what we call Fuck It Friday stream, where we just say F it, and we open up this to a panel of guests. You bring your money. You give me super chats. Throw all your super chat money at me on Friday. Get it out of the way on one day of the month. And every $100 that comes in, I do a shot of premium whiskey. I'll announce the whiskey tomorrow. And we are celebrating several things. It's the grand convergence. This Friday's F Friday stream will celebrate 75,000 subscribers. It will celebrate my 2-year anniversary on YouTube. So send me lots of happy birthday money gifts. And it will be celebrating my vacation, my hard-earned vacation coming up at the end of this month, and it will hopefully fund my vacation. So it is just a pure griftathon, which we do once a month, all in fun. We just know you just throw all your money at me on that one day, and we have a good show. Right now, our guest list consists of Hayden, Aussie Overlord. It consists of Jess, Moxie Dame, Danny on Direct, MG Law, Paralegal Liz, Nick Starro, Kaiser Pineapple, Runkle of the Bailey, and quite possibly Andrew Branca, Law of Self-Defense, and that Star Wars girl, Anna, Meme Copium, Josh from Japan. Those are the people that have responded so far and have expressed interest. Oh, we've just got a quick breaking here. Okay. Oh, wait a minute. What do we got here? DUI guy Larry says Chandler and I are going to be at the Karen Reed trial in Dedham. So if we get time during the break, ooh, that'd be fun. Otherwise, we'll be free up after 4 or 5 p.m. Eastern time. Hopefully, I'll be dead by then. Okay, so Chandler and Larry will be at the Karen Reed trial. That'd be cool. All right, that's what we got coming up this weekend. Thanks, everybody, for being here. Let's go see potentially criminal Sean. And Yes, you've known me for 2 years now. Time flies. See Potentially Criminal Sean. Say hi. Legal Vices sent you. And join us tomorrow for Karen Reed and Karen Reed Bingo. See everybody. Take care. Bye.